Turn off your videos, please. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning, everyone. Can everyone hear me? Can everyone hear me?
Yes, I can hear you, Your Honor.
Very good, thank you. Good morning, everyone, and welcome to the 4th Court of Appeals. At this time, the current environment precludes us from holding our live arguments in our courtroom at the Cadena Reeves Justice Center in San Antonio, Texas. The court welcomes the advocates on this Zoom virtual platform, as well as the interested parties and general public viewing these proceedings as we live stream them on the 4th Court's YouTube channel. Please be aware that should we suffer any unforeseen technical difficulties, I will stop the clock. If necessary, I may temporarily suspend the proceedings and the judges will recess briefly. Our clerk of court, Michael Cruz, will provide you with further instructions and assistance as needed. Once resolved, I will resume the hearing and counsel will proceed for the time that remains allotted to him. As you, in light of the virtual nature of these proceedings, I wish to provide you with some guidance to help navigate through the panel's questions this afternoon. The justices have decided to raise their hand like so when she wishes to ask a question. I may have to verbally interrupt you respectfully should your attention veer away too long from the screen to notice a raised hand from one of the panelists. At this time, beginning with counsel for appellants, I call for announcements. In cause number. Yes.
May I interrupt? I would like to ask Michael Cruz to please release the video. I can't release it.
Forgive me, I did not notice. My panelists will include Justice Patricia Alvarez and Justice Lisa Rodriguez. And can the clerk resume video for Justice Alvarez?
Yes, we're working on it. There you go. Thank you.
There she is. Thank you. Again, at this time, beginning with the appellant's counsel, announcements in the matter of Carol Ochse and William Ochse, forgive me if I slaughter that name, individually and as trustee of the Family 2008 Trust versus Cynthia Cadwallader Ochse in cause number 04-20-0035-CV. Counsel for the appellants.
The appellant Carol Ochse, my name is Mark Canan, and I'm ready to proceed, Your Honor.
For the appellant William Ochse III, Les Katona Jr., I'm ready to proceed, Your Honor.
Good afternoon.
Your Honor, for the appellees, Cynthia Ochse, James McNeil.
Very good. It is my understanding, counsel, that Mr. Katona and Kanan will be dividing argument this afternoon, 20 minutes for Mr. Katona. Is that correct?
No, Your Honor. Mark Canan, I will start.
For Mr. Canan. Very good. And the rebuttal will be left for Mr. Katona.
Correct.
Very good. Counsel, you may proceed.
Thank you, Your Honor. The issues before the court really are very singular. The issue is very singular. That issue is a trust document establishing a trust back in 2008 by Amanda Ochse, the primary beneficiary of which was her son, William Ochse III. There were beneficiaries also identified by their relationship to Mr. Ochse III, those being his descendants and identified as the son's spouse or the primary beneficiary's spouse. In 2008, Mr. Ochse was married to the appellee Cynthia Ochse. They were divorced in January of 2013, and in September of 2015, Mr. Ochse married my client, the appellant Cynthia Ochse, and has been married to Cynthia Ochse since that time. The issue, as I'm sure the court is well aware, is the terms of the trust that identify one of the beneficiaries as the primary beneficiary's spouse or the son's spouse. The position of the appellee, Cynthia Cadwallader Ochse, is that since she was married at the time in 2008, that for all times thereafter, irrespective of any changes in conditions, she is the spouse, irrespective of whether the actions taken are present day actions, future actions, or the like. And the position that we take on behalf of Carol Ochse is that she is the spouse currently of the primary beneficiary, William Ochse III, and that to the extent that William Ochse III has actions that can be taken for the benefit of beneficiaries at this time, that the beneficiary who is the son's spouse or the sole beneficiary's spouse for those actions, whether they be distributions or appointments, at this time refer to Carol Ochse. And at issue will be the rules of construction for wills and trusts. And the primary objective and under any of the cases is to determine the intent of the maker of the trust. And that is a question of law reviewed de novo by this court. It was presented to the lower court as competing motions for summary judgment. The lower court determined that the summary judgment of Cynthia Ochse was to be granted, and it was. The summary judgment on behalf of the appellant, Carol Ochse, was denied, but the issue, of course, is who is the spouse. And the determined, yes, Your Honor.
Is the dispositive issue, in fact, who is the spouse? The appellee has countered your argument that the divorce and Williams and Mr. Williams' second marriage does not affect the appellee's status as a beneficiary of the trust, because the trust is in fact irrevocable, and the beneficiary's interests and rights in the trust vested upon its effective date. How would you respond to those arguments?
The issue of, to take them in order, the issue of irrevocability really doesn't apply to what we're looking at here today. The intent of the maker, obviously, in using the term spouse in 2008 is where the inquiry is focused. And whether the trust was revocable or irrevocable, the meaning of the term would have no relationship to whether the trust was irrevocable or not. In fact, as pointed out, I think in our reply brief, the determination as to whether a trust is irrevocable or not is really an estate and tax planning determination made on the part of the grantor. That it has nothing to do with the construction of the meaning of the language within the document itself, which would be the same, as I say, irrespective of whether it was revocable or irrevocable. For example, the issue comes up many times in will contests. And the question of what, in many of the cases, in fact, that have been cited, since the rules of construction are the same, are will cases. Well, of course, wills are revocable documents. They're revocable up until, if I could say, up until the last day, I suppose. But it doesn't change the construction and the interpretation of the language. Frankly, the fact that the document is irrevocable is an argument for looking at it in a dynamic sort of way and not in a static way. If an irrevocable document is created in 2008, it's certainly done so with the knowledge that conditions are going to change. And therefore, the document is constructed in a way, and this document is, as we look through it, it's constructed in a way to appreciate the dynamic nature of the conditions that would affect the application of the trust thereafter. And so the irrevocability really is a reason to look at the document in a way that's dynamic and allows for changes, because certainly and somebody offering a state guidance is good. I'm sorry, did I go off too far? Sorry, Your Honor, go ahead.
Not at all, but you make certain, you present certain foundations for your argument that one might dispute. Certainly the difference between a will instrument and a trust instrument, those differences are obvious and clarified in case law. You've provided this court no precedent from Texas to support the arguments, novel, I might add, arguments as to how this court should identify the intent of the grantor in this particular instrument, a trust instrument. Would you first agree that it is unambiguous, the trust itself? I don't believe any contention by the appellant that it is ambiguous. Could we start off there?
I think both sides start out there, Your Honor. That's why I suppose we have motions for summary judgment.
Very good. And so if the meaning of the instrument is uncertain, certainly we would construe the instrument as ambiguous. Here, given the concession that again, it is an unambiguous trust instrument, and in carefully examining the words used throughout that instrument within the four corners of the document, how would you show specifically what language in the trust instrument would not in some way be tweaked in some way by adding essentially what the appellant proposes is to add the word then before the word spouse when used in the trust instrument to effectively indicate the grantor's intent that the instrument should be deemed based on then spouse of the beneficiary, in this case, Mr. Ochse.
Well, of course, the word then is not there, as the court pointed out. I'm sure that both sides could play woulda, coulda, shoulda, and wish that certain language was there. But I think the language that is there pretty clearly indicates that this was not written in stone for the conditions that existed in 2008. For example, when we look at the overall trust arrangements for distribution and appointments, whether they be the continuing distributions or the power to make distributions on the part of the trustee or the inter vivos or testamentary appointments, the language in each instance, and I'll quote from, with respect to distributions, they're distributions that's made from time to time, or when we look at the inter vivos appointment power, at any time and from time to time. Or if we look at the testamentary appointment powers, is at any time and in all events. And with respect to the appointment powers, the language also reads, subject to the terms and conditions as the primary beneficiary may direct. Now these are all indications that the conditions would change and that the decisions and distributions and appointments would be made based upon the conditions at the time or from time to time or in any event as specified in the document. Now, there are other indications that the document was not static as of 2008 as opposed to dynamic. And look, for example, at the withdrawn powers of withdrawal by the beneficiaries. Article 2 of the trust document on its face would seem to give to the beneficiaries in 2008 and continuing thereafter a vested interest to make withdrawals in the from the trust. However, the notice of contribution to the trust, which initiated the trust by Amanda Ochse, specified, and I set this out in our reply brief, it's in page 318 of the clerk's record, the notification that the contributed property, that is all the assets going into the trust, shall not be subject to a right of withdrawal by any beneficiary of the trust, notwithstanding, any provisions of the trust agreement to the contrary. So in 2008, rather than give a vested interest to, at that time, Cynthia and the descendants at that time, there was no vested interest granted, that in fact no withdrawals were allowed, other than in the dynamic nature of the distributions and appointments as otherwise set forth from time to time and in all events. So certainly that language suggests that the document was not static. I'd also point out that the fact that there was no name attached to the identification other than son, spouse, or primary beneficiary spouse. Certainly in 2008, there was a named individual who fit that bill. And in fact, within the document itself, you'll note that Cynthia Cadwallader Ochse was identified by name as a trustee, as a successor trustee, rather. So Amanda Ochse, obviously in 2008, knew how to identify Cynthia Cadwallader Ochse if she so intended to identify that person but as her son's spouse, but chose not to do that. Yes.
Justice Alvarez would like to ask a question.
Sorry,
I don't think, yeah, how you doing, Mr. Cannon?
good afternoon.
You know, your argument fails if we take the whole document. Yes, she was an alternate trustee or a successor trustee. She was named, okay, but isn't the fact that she was named, does that mean that she also was the spouse who was named? To me, that fails. To me, you have to look, well, let me ask you the question. Why do you think it doesn't fail?
Well, because the intent was to identify a status or a category. And I'll add something to that argument. There's also within the powers of the trustee, within the document, the contemplation that the grantor, that is Amanda Ochse, may have property to contribute to the trust at the time of her death. And that portion of the document, the trust document, allows for the possibility that at the time of her death, when that property would go to the trust, there may be a community interest existing for her husband. She had no husband in 2008. There was no individual who could be identified as her husband in 2008. She obviously allowed for the possibility that between 2008 and her demise, she may have a husband who could not be named at that time. And so she used the term, the spousal term husband, as a category or a status as opposed to a person. So in describing a beneficiary of the trust with a spousal status or category as opposed to a name, that is comparable to what she did with respect to leaving the door open for a future husband. She left the door open for a different spouse.
Yeah, but that's very speculative. In interpreting contract, we can't speculate, and you would agree to that.
No, I'm not speculating. I'm looking at the document itself and the four corners of the document, and the four corners of the document, how she used spousal terms, including husband, was in a way to describe a category or a status as opposed to a person. She knew how to identify.
Justice Rodriguez would like to ask a question.
Yes, hi, good afternoon, everyone. I wanted to direct your attention to the Pennsylvania Supreme Court case that you cited.
The Busby.
And yes, and talk a little bit about that one, because in that case, the premise is that it involved a will, and the spouse was identified at the time the will was executed. Is that correct? Am I understanding that?
Yes.
Okay. So how do you reconcile that with this case where when the trust was executed, we had a spouse, and that was Cynthia Ochse. So how do you reconcile those two things?
But she wasn't identified. Whereas in the Busby case, as well as the other out-of-state cases, the New York case, the Michigan case, in which the appellee asserted there's some sort of general rule in favor of current spouse when spouse is used, that in each of those instances, including Busby, the court looked at the document itself to see if somebody was specifically identified by a characteristic. And in each of those cases, someone was specifically identified by a characteristic. It didn't turn merely on the phrase wife or spouse. And so what I liked about the Busby case and why it's in my brief is that they clearly said we should not have an inflexible rule that wife means current wife or whatever, but rather we should look at the entirety of the document. And I think when you look at the entirety of this document, the manner in which Amanda Ochse used the term spouse was in a categorical way describing a status is.
But who was he married to in 2008? Who was William married to in 2008 when the trust was executed?
When the trust was executed, he was married to Cynthia Ochse.
Is it possible to deem within the four corners of this instrument, having had Cynthia named specifically in other parts of the instrument as an alternate beneficiary in some ways, and while after the first use of the term spouse, she was named specifically, it would be consistent with the interpretation of the entire document that would not raise ambiguity to any remaining terms. The appellant's arguments regarding some sort of class definition for the term spouse, as we've often used for descendants, children who might be born after the instrument is executed, any lineal descendants, for example, a class when the maker might intend to include them but cannot immediately identify them as a specific individual who would, receive a benefit from her bequest. How would we? You provide no case law to even suggest that the term spouse, which is usually one person at a time. We are not in a community where one can have more than one spouse, and one at the time of marriage also don't anticipate, I would imagine, having a class of future spouses. How would you respond to, a defense to your argument about allowing, the jurisprudence of Texas to expand the term spouse to be intended to be a class gift when not specifically indicated as such by the grantor?
I don't intend it to be named a class necessarily. It's a status and a characteristic. And I use the term that you just used, one spouse at a time. That's clearly the case. And you raised the issue of descendants. Let me make reference to a case I came across recently that I think is instructive.
And I'll remind you, you've got 5 seconds left to your
I
time.
present this case in a letter to the court.
Allow me, Justice Alvarez actually would like to have a question.
No, I'd like Mr. Cannon to tell us about the case, and I'd like to ask him one last question if possible, Justice Martinez.
Very good. Please proceed.
I'll do it as quickly as possible. It's Paschall, P-A-S-C-H-A-L-L versus Bank of America. It's a no petition case out of the Dallas Court of Appeals, reported at 260 Southwest 3rd, 707. And the issue there was the use of the term descendants. And the court recognized that there were actually 2 definitions of descendants that were being presented by either side. One being the legal term, that is the issue of someone who is deceased, and the other using what the court calls the practical term, irrespective of whether the descendant was from someone who was living or not. And the court, to determine which use of descendant was applicable and which the grantor intended to have used, looked at the 4 corners of the document and very significantly looked at the fact that it was a dynamic document in which distributions were to be made from time to time. And because of the manner in which the document was written, indicating that it was going to extend over a period of time when the trustee would make discretionary distributions, that they took the practical as opposed to the legal definition of descendants. And that was all within the context of interpreting the document by looking at it within the 4 corners. And I recommend that case to the court. Thank you. And Justice Alvarez had a question, I believe.
Yes. And going back to what Justice Rodriguez was trying to point out, I just want to make sure that I understood your response to her question. At the time, we're supposed to see the intent of the mother at the time that she created this document. You would agree with that?
Yes.
Okay. So if at the time she created the document, she did not put, my son's spouse and any subsequent spouses, then you would agree that your argument is, bottom line, adding things to the trust document that is not there.
Well, in the same way that the other side would like to say his then spouse. And that language is not there either. And that's the would.
No, I agree with that. Not then, but it's the spouse, the son's spouse. So we have to go with the son's spouse, not a subsequent spouse, and the son's spouse at the time of the document. You would agree with that?
Ultimately, no. I think that the document has to be looked not at those particular words, but it has to be within the 4 corners of the document. And bear in mind that the primary beneficiary was the son. And to so restrict the son in terms of any subsequent changes in his conditions is not reasonable in terms of what the mother was intending to do in 2008, and that is to benefit the primary beneficiary of the trust, that is the son, and some folks who had relationships with him.
Thank you, counsel. You'll have 10 minutes for rebuttal, and I invite Mr. McNeil.
Thank you, Your Honor. My name is, may I proceed?
Please do.
Yes. May it please the court. My name is James McNeil. I'm counsel for appellee Cynthia Ochse. This case involves the interpretation of the William Ochse III Family 2008 Trust. The trust was created in 2008 by Amanda Ochse, the grantor. And in the initial trust property statement, the very first paragraph of the trust, her intentions are stated very clearly. She says, the grantor is desiring to establish a trust for the benefit of her son, her son's descendants, and her son's spouse has, and she talks about the property she attaches, delivered to the trustee those assets delivered on Exhibit A. And that's all of this is very significant because this is the clearest statement of the grantor's intent. She's intending to benefit her son, her son's descendants, and her son's spouse, all of whom are clearly identifiable in 2008. Her son was William Ochse III. Her son's spouse was my client, Cynthia Ochse, and had been the spouse for 30 years at that point. And her son's descendants were her grandchildren, William Ochse IV, and Chloe Ochse, who were both grown at that time. Even more significantly is what's on Exhibit A. Exhibit A, the assets that were contributed to the trust, were 850 shares of C.H. Gunther and Sons stock. This is a company that has been in the family since 1851 and was in the family until the company was sold in 2018. And that was the only property put into the trust originally in 2008. And the reasons that's significant is it ties in with the overall intent of the document that this was a significant family asset. And if you look at the entire document, there's nowhere in the document that the grantor intends that the property go anywhere but to her family, meaning her son and his spouse and their descendants, or alternatively at the farthest part of the family to her daughter and their descendants, because the power of appointment does speak to grantor's descendants, not just the son's descendants. So there is no part of this trust document that reflects that the grantor intended that this family legacy asset go to any other person other than someone in her immediate family. Now, the key issues in the case that we feel are before the court are, did the court err, the trial court err in defining the word spouse as it's used in the trust to mean who was the spouse in 2008 when the trust was created, who was her daughter-in-law of over 30 years at that point, and the mother of her 2 grandchildren? Or did she intend it to mean some spouse in the future that she may or may not know? Yes, Your Honor.
Yes, sorry to interrupt you, but I wanted to ask you on the appellant's point where he discusses the fact that the grantor did make a gift also to the husband. How do you, to her husband, which she did not have at that time, how do you reconcile your position with the fact that she used identifying language in the form of a descriptive status? How do you reconcile your argument then?
Sure, Your Honor, because at the time, as counsel for appellant stated, the grantor had no husband, but she was leaving open the possibility that if she did marry, that husband could leave additional property to this trust. Since the court has to look at who was there and what the words meant in 2008, she didn't have a 2008 husband in 2008, but she might have had one in the future. So the document was drafted to address that contingency if it ever occurred. It doesn't change the fact that the beneficiaries were ascertainable and identifiable in the document when it was created.
And so your argument is that she couldn't have anticipated that her son would remarry at any time in the future and that status couldn't change? Is that
well, she certainly could have, Your Honor. I think that's a fair point. However, as I think the court's pointed out in some of its questioning, there is no additional language that would suggest she contemplated that as an option to create an additional beneficiary in the future, because if she had done so, she would have had to use some words like then spouse or the spouse at the time or any spouse that my son may have at any point in time in the future. There would have to be some qualifying language to suggest that the term spouse was somehow transitory, not to mean just one person, meaning the person that she intended to benefit at the time the trust was created. And that language just doesn't exist in the trust. There is no language that suggests that the son as a primary beneficiary could then substitute beneficiaries from what the grantor intended when she wrote the trust. It's our position that additional language would be necessary in the trust to establish that intent by the grantor. The other significant issue that we think is before the court that is related to the first issue is, did the grantor intend for her son, William III, using his powers to be able to appoint away the entire family legacy asset to a complete stranger in the future and away from her descendants, as the trust states? And we think the answer to that is no. As the court's well aware, Texas law is clear that the cardinal rule in interpreting trust where there's no ambiguity is that you're supposed to read the terms to ascertain the settler's intent to the truest extent possible of effectuating it. Secondly, and more importantly, I think, is the court must look at the intent at the time of the creation of the document, not at some later date. So we have to take a snapshot of what these words mean in 2008. The argument that the son's spouse is somehow a status and not a person is contrary to what the cases hold and what the rule is in Texas. And in particular, the restatement of trust, section 44, clearly states that a beneficiary need not be named by name, but can be named by category or position. And that is what happened here. So it's not a requirement that the name of the person be put in the document for people to understand what the intent was and who the beneficiaries are. That's not a requirement. So without that requirement, in looking at the document and interpreting who these people are in 2008, again, they've been identified and they are the same people now as they were then. Secondly, the vesting issue, and I think this was raised by Justice Martinez, the vesting issue is very important. In Texas, the rule is that unless there's a power of revocation in the trust, the trust property vests immediately in the beneficiary the moment the trust is created. So the issue of revocability is very important in this case because this was an irrevocable trust. And so the property vested in the beneficiaries at the time it was created in 2008. There was no other language in the trust that would divest these beneficiaries of their interest. And the appellants can point to none. If the trust, yes, Your Honor. Yes, Justice.
So the appellants do argue that that your client cannot retain the title and benefits under the trust because the divorce effectively terminated any of her rights under the trust. Of course, I understand both parties don't cite any Texas authority on the issue of how a divorce affects a spouse's interest in an irrevocable trust. Have you, since your filing of your brief, found any and respond to the appellant's contention again about the effect of the divorce on her rights under the trust?
Yes, Your Honor. I do believe our brief does speak to this issue under the Family Code, section 3.001, as well as the Texas Constitution, Article 16, section 15, which clearly state that any gift or devise during a marriage is that spouse's sole and separate property. And the divorce, and we talked a little bit about the divorce, the agreement incident to divorce, where the parties acknowledge that whatever interest they have in the trust remains their interest in the trust. And that's more of an acknowledgement. It doesn't really determine what their property interest is in the trust because that was established when the trust was created. This was a gift to her daughter-in-law by the grantor of this trust interest, just like it was a gift to her son and her grandchildren of their interest in the trust. And that gift was effective immediately. It was a completed gift. And so that gift of property is a devise or gift from the grantor that can't be taken away from Cynthia, from her son, or from the descendants. So the divorce would have no impact on it whatsoever because it's not, I think the confusion in that issue lies in the fact that where there's a divorce between two people, then they, that's the case cited by appellants is that they're like complete strangers and the court decides what property they have and what they don't have. But that doesn't, the court has no power to take away the separate property gifts that party has from a third party, whether it be someone in their family or someone else outside of their family. And in particular, this is a gift in trust, which was to extend, and at the time of the divorce was still in effect, is still in effect now. And so the divorce court had no power to amend that trust or to change the terms of that trust. The only way in Texas to change an irrevocable trust is to go to court and ask the court for relief to modify or reform the trust under the Texas Trust Code. Outside of that and getting a court order changing or modifying or reforming the terms of the trust are effective upon the date that the trust is executed and funded. So that's why the issue of irrevocability is important here, because in like I think the court has mentioned, in a will case, and I think the cases speak to this, vesting occurs not when the will is executed, but when the testator dies, because that is the point when the will can no longer be revoked or amended. Same with a revocable trust. Yes, Your Honor.
Forgive me. Pardon me. Of course, again, I don't believe you pointed to any authority showing that how an irrevocable trust assists this court in determining the meaning of the term spouse within a trust. One can agree that, you know, an irrevocable trust terms cannot be changed by the settlor once, you know, property is conveyed into the trust, but that's for other purposes unrelated to our charge to answer those two particular issues. So with respect to, you know, reference to the family code or even statutes guiding us on irrevocable trust, we are still limited to, again, the four corners of this instrument to best clarify the intent of the testator. Focusing on that issue in particular, how would you respond to the appellant's arguments laid out in their brief and argument here?
Yes, Your Honor, thank you. Again, I think the issue of irrevocability doesn't decide the status of who the beneficiaries are, but it merely is important because that status can't change because the trust is irrevocable and the benefits of the trust vest immediately in the beneficiaries. As to the appellant's arguments about the powers of appointment language that they think gives their client a right to substitute beneficiaries, the words at all time, at any time and from time to time speak only to when the power of appointment can be exercised. So for instance, with the inter vivos power of appointment, the son as the holder of that power could exercise his power of appointment in any particular year to appoint away, say, 50 shares of stock in 1 year, and then 5 years later, appoint away another 50 shares of stock. It's just not a limitation on when he can exercise it. He's allowed to exercise it at any time and from time to time until the termination of the trust. That in no way, and they've cited no authority for this, changes who the beneficiaries were and the date the trust was created. Secondly, the issue of in all events language that they point to in the testamentary power of appointment. And I would, if it's allowed by the court, direct the court to an additional citation. This language in all events is very specific, what would be called magic language or term of art language that's required to qualify a marital trust for the marital deduction under the Internal Revenue Code. And so that language is required under that provision in the Treasury regulations. And I would cite to Treasury Regulation 20.2056, little b in parentheses -5, which lays out the different ways in which a trust can qualify for a marital deduction trust status under the Internal Revenue Code. This is not a marital deduction trust. It's not a trust where one spouse left property to another spouse. So that language is inapplicable here. Secondly, they don't point to any authority that would suggest that in all events means that the term spouse as it was defined when the trust is created would somehow change from that person that was intended to some other person at a later date. Yes, Your Honor.
So we know that an irrevocable trust terms can't be changed, as you just said, once the settlor has conveyed the property, properties conveyed to the trust. And certainly an individual generally creates an irrevocable trust to reconcile two opposing objectives of avoiding estate taxes, as you referenced the tax code, but also to maintain control over assets. Was there any benefit to Amanda as grantor to provide for a potential future spouse? I digress, but I'm wondering, since you raised the point of incentives under the tax code.
Well, I was just raising the tax code to address that specific language as to how a trust, one of the ways a trust can qualify as a marital deduction trust. But who the beneficiaries are in this context, because this is not a marital deduction trust situation, would have no impact. What Amanda was trying to do with this trust in transferring this property was to transfer the value of that property into this trust to get it out of what would be her taxable estate. And so the purpose
Right, and to also provide for a potential future husband to also convey property into the trust, as pointed out by appellants, that was another indication of a possible intent to provide for future spouses. But I digress, and I'm curious whether you knew anything about the tax code. But again, I don't mean to digress too much.
I do know some, but I just would say that her use of the language of husband when she didn't have one is just a kind of a prophylactic to say that the trust in the future could receive assets from that person if they ever existed. It doesn't change. It doesn't change who she intended to be the beneficiaries at the time the trust was created.
Right.
Those people were identifiable and ascertainable at the time.
Would construing the word spouse, not so much as a class, but as a term to be identified at a time beyond the date that the trust was executed or created, would doing so conflict with any other language in the instrument, making other portions of the instrument ambiguous?
I don't think it would make other portions of the language ambiguous, but it would defeat the purpose of the trust, which was to benefit her descendants ultimately. If there was some other stranger beneficiary that could receive the property, that would defeat the purposes of the trust, which were for her family to benefit from these assets, not someone she didn't know. And speaking to
a future spouse would be family. I think that's what appellants are arguing, is that a future spouse, if she wanted to include family, that spouse should be identified as, then spouse, which would include the appellant. If we were to construe it that way, again, anything in the instrument that would be inconsistent with that, aside from the fact that Cynthia has been, the now ex-wife has been identified, has been given a role in other parts of the trust.
Right. I think in looking at the intent, Your Honor, there has to be some other language to suggest that she would mean the word spouse to be some transitory term that could change over time, and there just isn't one. And I think the Eakins case that we cited, which I know is a New York case, but it follows the rule of Texas, which as you interpret the document at the time it's created, speaks to that issue very directly in saying, in particular, that the grantor could not have expected that the second or third wife would leave property to her grandchildren since she was not their mother. So the expectation that a future spouse who doesn't appreciate the significance of this asset and who has no relationship with these children and grandchildren would want to leave the property to them is an unreasonable interpretation of her intent.
Is there an intent to exclude any children that might William have that were not given, that weren't birthed by his first wife, but a subsequent wife, or even non-spouse? I mean, was there any indication that any other children, adopted or born to William, be specifically excluded?
Well, the adopted portion is dealt with because the descendants in this case were adopted by William and Cynthia. They were the only children at the time. And again, at the time of the trust was created, William and Cynthia had been married for 30 years. And I think that it was unlikely that anyone expected them to have more children at that time. But the word my son's children or my son's descendants certainly is a class term that could grow. And in particular, I think the expectation was that it would grow through grandchildren and other descendants down the line, although there's no restriction on that, as the court points out. So people were still identifiable even at that time, even though descendants is a class that can grow over time.
Thank you. I see that your time is up. Any questions from the justices? Very good. Back to counsel for the appellants for 10 minutes of rebuttal.
Thank you, Your Honor. Obviously, the issue of irrevocability is of interest to the court. And I would point out that an irrevocable trust is simply a trust in which the grantor cannot take back the money or change the language used in the document. It does not mean that there is not room for interpretation of the language used, nor does it cast in stone the position of individuals who might be described by category or position. And so the fact that this trust is irrevocable simply doesn't answer the question that's before the court, and that is, what did Amanda Ochse mean when she used the term "my son's spouse" or "spouse" in this document? Even the argument made by the appellee's counsel acknowledges that within the restatement, there is a recognition that certain terms refer to categories and positions which change over time. And that is what the use of spouse is intended to do here. It is intended to allow for a change in position, that is, who holds the position of spouse. Amanda Ochse in 2008 knew who her son's then spouse was. What she did not know was whether or not Cynthia Ochse might die, or, as was the case, would become divorced from her son. She did not know who her spouse might be in the future, but the language she used demonstrates a clear intent to provide for that person.
Mr. Katona, let me interrupt you. Your co-counsel made a very compelling argument, and Justice Martinez kind of developed that with your opposing counsel regarding the fact that the grantor put "in my husband," okay? But wouldn't you agree with me that whether she had a husband or not, okay, at the time, it is irrelevant for purposes of interpreting your side, which is the son's spouse, because what we do is we look at the four corners of the document.
Respectfully, no, I would not agree with that, Your Honor.
Okay, why not, please?
Because terms of referring to a marital relationship that are used in this trust, there are only two. One is spouse and one is husband. There are other times within the four corners of this document where Amanda Ochse intended for certain people to have rights or obligations, and she identified them by name. So when you look at the document as a whole, when Amanda Ochse was referring to someone when she was referring to a position or a category where she didn't know the name of the person who would occupy it at the relevant time, she used a descriptive term such as "my husband" or "my son's spouse." When she intended a very specific person to have a right or obligation, she identified them by name. And I direct the court's attention to the trust document, and the page in the record is 240.
So going back to my question, Mr. Katona, do you say that it's not irrelevant, the fact that she was not married at the time, that she was never married, and that she put husband, and that's irrelevant to the interpretation of the four corners of the document?
No, I think it is relevant because she did not have a husband at the time she was writing this document in 2008, but she contemplated that she might or she could.
I don't think you understand my question. Sorry.
Do I proceed or?
Please do.
Okay. And then let me just develop that comment just a little bit further. When Amanda Ochse knew the identity of the person she wanted to have a right or obligation, she identified them by name. By way of example, at page 240 of the trust document in section 5.3, at the very end, she identified Cynthia Cadwalder Ochse and Jack C. Hebden. Those are individuals, she knew who they were. She wanted them to have that obligation. She named them. Had she intended in the earlier portions of the document providing for distributions and powers of appointment for Cynthia Cadwalder Ochse to have those rights, she would have used her name there as she did in section 5.3, or she could have used.
Where in the how is Jack identified in the record? I noticed his name there, but I'm not certain if the record reflects who the gentleman is.
It does not reflect his relationship to anyone. It simply identifies him as an individual who would be a successor trustee if one of the other named trustees did not serve.
Please, thank you.
Or as one of the justices pointed out, had Ms. Amanda Ochse intended for Cynthia Cadwalder Ochse to have distribution rights and appointment rights, she could have then written in then spouse. And the fact that she didn't do it there and she used actual names, not descriptive terms in other parts of the document, in our argument means that when you read the document as a whole, when Amanda Ochse wanted to benefit a person, she named that person. When she wanted to describe a not static or dynamic class or position, she used those terms, which is what she did. I want to address.
Is it your client's contention that a future wife was intended to be defined as the spousal beneficiary, but also replace the first known wife in other parts of the instrument where she's identified specifically?
It would not be our argument that where Cynthia Cadwalder Ochse is identified by name, that a future wife was intended to take that place. There's no expression of intent for that in the document. When Ms. Amanda Ochse wanted to make sure that an individual received a right or obligation, she named that person by name.
And the obligations to Cynthia at that time were?
She had no obligation at that time. She would have the right.
Roles.
She would have the right under section 5.3 to be a successor trustee, and that's it. And it would be a successor trustee of trust, which would primarily be for her children at that time. I want to address.
Justice Alvarez would like a question.
Yeah, I just want to make sure that I understand what you're saying. My understanding is in the interpretation of any contract or any trust or any will, you look at the four corners of the document, correct?
Yes.
Okay, and you don't look at any evidence outside, correct?
That's correct.
Okay, thank you.
I want to address an argument made by opposing counsel that there was some family legacy in the C.H. Gunther stock and that Amanda Ochse had some intent of dealing with that stock, and that's the reason she used the language she used. There is nothing in the record, and certainly nothing within the trust, which supports that argument that the Gunther trust was a part of some family legacy, or that Amanda Ochse intended to treat it as such or have it be treated as such. And that's simply a red herring in our view. There was also an argument made about a gift, and opposing counsel said there was a gift made to Cynthia Cadwalder Ochse. There was no gift made to Cynthia Cadwalder Ochse, period. There was a contribution made to a trust, but there were no gifts made to Ms. Cynthia Ochse or to anyone else. It was simply a contribution which created a trust. And then the final point I'd like to make is that opposing counsel made reference to a marital deduction trust and magic language which appears in the IRS code. And that was, I believe, intended to discount the meaning and significance of the language from time to time or at all events, which is contained in the lease. And of course, as opposing counsel conceded, and as one or more of the justices noted, this is not a marital deduction trust. There's no evidence it was intended to be, and there's no reason or applicability of the language that was referred to. The language from time to time and at all times indicates within the document a clear intention by Amanda Ochse that circumstances would change and that the individuals who would be identified by the categories or positions she was describing would change from time to time and would be relevant in all events as they existed at the time.
Council Justice Rodriguez has a question.
Yes, thank you. I just had two quick questions. So are you saying, counsel, that that Cynthia did have access to the trust once it was established, although I guess your argument is she wasn't gifted anything at that time, but did she have access to the trust once it was established?
No, Your Honor, the trust doesn't provide for her to have any access.
Okay. And then the second question I had was on the case law. Did you find any cases that that categorized or identified spouse as a class? Any Texas cases where they identified spouse as a class? Like I know there's case law where they identify children or descendants as a class, but did you find anything like that?
No, didn't find any that said it was a class or that definitively said it was not a class.
Thank you. That's all I have.
I believe my time is up.
Thank you, counsel. Thank you to both counsel. Your case is now submitted and an opinion will be forthcoming. And we will, the court will now be in recess. Have a good afternoon.
Thank you, Your Honor.
Thank you, Your Honor.